All right, thank you all. I apologize for the delay. Thank you for all bearing with us. I call this meeting back to order. This is now the afternoon of June 3rd, 2026. The time is currently 1:13 p.m. Before we pick back up, I think we're waiting for Commission Council now. McCall. I'll just start by picking up where we left off, but also I want to apologize to the commission. I think I confused everybody because I didn't realize that some things were double-sided on the printouts here. And so I was looking at the wrong section. And I think that might have been part of the confusion here. So now let's see if we can maybe re-pick up at the beginning of proposed changes to NMAC 1915-5. And now that I'm looking at 1915-5-9A4, I'm looking at the applicant's proposed post-hearing final amendments, proposed amendments, as well as the table reflecting the joint stipulation. And I understand from our hearing officer that there is also there's alternate proposed language from IPNM that is not part of the stipulation, right?
No, not IPANM, NMOGA.
My apologies, yes.
Yeah. So 1915.5.9 is important because compliance criteria control operator registrations and transfers, and as proposed, releases of financial assurance. NMOGA counter proposes to the stipulation that the exceptions here would be retained or at least not done away with all at once. Perhaps they could be done away with over time. Through the negotiations, the applicants did agree to add back the compliance order exception, which they had lined out as part of their original proposal, noting that the compliance order needed to impose sanctions, for example, that it was a meaningful compliance order, impose sanctions if the schedule was not met. The other thing that NMOGA took special note of here is the reference to Part 27. Part 27 is not being changed as part of this rulemaking. That's the venting and flaring compliance section. So that's the other thing NMOGA opposes, is the reference, the cross-reference, if you will, to the venting and flaring compliance.
That's 1915-27-8A through D, is that right?
Yes, right there.
Perfect. Okay. And even though there is a alternative being proposed by NMOGA in the record, am I correct in reading the table of negotiated language that NMOGA nevertheless, while reserving their right, does also note at least a concession, if not full agreement, on the proposed language from the applicants as part of the stipulated final, correct? Because I'm seeing blue AR on the table.
Right. My understanding of their agreement is they do not disagree, or they concede that there's substantial evidence in support of the applicant's proposal.
Okay. So commissioners, now that we've had a chance to review the proposed changes in front of us, the various alternative proposed changes in front of us for 1915-5-9A4, do commissioners have a preference as to what we wish to adopt? Or do commissioners wish to find any of them to be well taken and supported by substantial evidence?
Mr. Chair, so from my point of view, I believe that what has been presented to us through the stipulation agreement, I do support that. Now, with what Nimoga is proposing, it sounds to me that it might negate, because if you look at what was agreed on, from the applicant's point of view, we are not leaving any room, for non-compliance. But Nimoga proposal more or less gives some allowance, which was in the original rules. So if we are to adapt Nimoga's point of view, then we would have to more or less rethink about even what was agreed on during the stipulation. So I will agree with the applicant on this particular matter. Thank you.
Thank you. Anything to add on that, Commissioner Bloom? You were up. You were about to. Well, if you need time to gather your thoughts.
But no, as I stated earlier in this section, this part certainly works for me, and that it establishes the newer compliance rules in line with the applicant's general proposal, which I've stated support for earlier. Thanks.
Great. I also, having reviewed the alternatives in front of us, I also agree that first of all, I think the applicant's proposed language here in the final joint stipulation is supported by the evidence in the record, and also has broader range of support amongst the parties than the other alternatives in front of us. And so I also think that is adopting the proposed changes to 1915-5-9A4 would be a better choice. So with that, is that the decision of the commission that we approve, that we support the applicant's joint stipulated final language for 1915-5-9A4?
Yes.
Yes, Mr. Chair.
Thank you so much. Now moving on to 1915-5-9A5. I believe this is all part of the same section. So is there any further discussion? And if not, do the commission wish to adopt the language for 1915-5-9A5 as well?
Yes.
I should specify as proposed by the applicant to the party's final joint stipulated language.
Fine by me. Thank you.
Mr. Chair, I'm not sure I'm looking at the right spot here.
Okay. I can assist. So we just approved that. So this next line is this currently meets the requirement of 1915-27A8A.
Still in B.
Mm-hmm. Yeah. We're just approving. Any objections to that?
Mr. Chair, no objections.
Okay. I don't have any objections either. So the commission will adopt 1915-5-9A5 with the language as proposed by the applicants. I will note that there, as far as it appears that there is, this is also one of the section that has more acquiescence amongst the parties than other provisions. Then moving on to 1915-5-9B1. There's two changes in B1A. Let's look at B1A. This is another provision that has relatively more support, if not unanimous support, but more support amongst the parties. Do the commission have concerns as to whether the proposed language here from the final joint stipulated language, or is the commission comfortable adopting it as sufficiently supported by the record?
Yes, Mr. Chair, I'm comfortable with that and would adopt B1, A, B, C, and D as well.
Okay. Commissioner Mpoma?
Yes, I'm also okay with that. I do not see any alternate language from Nimoga or IPNM. So I do support this too. Thank you.
I also find that there's sufficient evidence in the record to support this, and again, for lack of an alternative proposed, unanimously so adopted by the commission. So that covered A, B, and or subsections A, B, and C under B1. So now the last decision for this section, I believe, is 1915-59B2.
So, Mr. Chair, I have no issues with that. We're just changing 15 months to 14 months.
Commissioner?
Yeah, I do not have any problem with that. But I was curious why 14 to 15. But yeah, no problems. Thank you.
As was I. It looked like a compromise, Dr. Mpoma. That's what I'm going with.
Okay.
So adopted as joint as per the joint stipulation? Is that commission's decision?
Yes, sir.
Yes.
Thank you all very much. All right, moving right along. Now we're into 1915-8. I'm sorry? Thank you. If we could get a vote on the entirety of the proposed changes to 1915-5, or as presented in Exhibit 89B, or as reflected in the table in the negotiated language.
Mr. Chair, I would vote to approve 1915.5 as noted in the joint stipulation applicants 89-B.
Second.
Any commissioners opposed? Without opposition? So approved. Okay, moving on to debate on NMAC 1915-8-9. First change for our consideration is changes to 1915-8-9A. Commissioners, any thoughts? And according to the joint stipulation table, this is one of the provisions where there might be alternatives proposed for us to consider.
Chair, we have alternative language from both NMOGA and IPA.
Thank you. If you have them handy, would you like to quickly summarize them for the record here?
Well, that would be a long summary, frankly. This is really, I think, the heart of a lot of the proposals motivating the petition to begin with. Some of it goes to the legal arguments made by industry around their objection to the one well, if you will, determining financial assurance using the one well flat amount, $150,000. So I believe you might have covered some of this already this morning before I arrived. What else would I say about A? The parts challenged here are all in section 8.9. 8.9A, C, D, and E are the provisions, and you have quite a bit of alternative language here.
So what Sheila's done is wonderful. Let's use her work. So she put these binders together. Hopefully I'm using yours, Commissioner Bloom. So the last documents are maybe the ones, there's one that's tabbed IPAM. It's the third to last tab from the back. And it's titled Independent Petroleum Association's Proposed Alternative Language. I'm looking at that. It goes section by section. That's what their proposal is. The third tab that Sheila created from the back, and she wrote IPAM.
Unfortunately, my tabs are different from yours.
Okay.
So,
I can share with you or.
we got it. Those two should be the same.
And it's page 8 of that document.
All right. And then immediately behind that is the MOGA's
Yes.
And they've had like green language there. So if you want to use Sheila's work and say, what are the alternative language? Those are the two documents that you really should be like, okay, this one, compare it to exhibits. That's for the applicant.
So that for A, applicability, I do not see any proposed changes by NIMOGA nor by IPNM for the A. Even if you look here, so I'm looking at
Mr.
this.
Chair, I believe there is, when you look at the NIMOGA Exhibit 3, page 21. Commissioner, I think both these deserve some discussion. The first one is something that I suggested during the evidentiary hearing, where there'd be additional language to A saying that the division could exercise its discretion and waive its financial assurance requirement because the operator is engaged in plugging operations for that well to be secured, will be in the near future for any other good cause determined by the division. I don't know if I'd go that wide, but there's a basically what this would do would allow a company to drop their bond and use that money to plug a well or not be bonded. And, with the OCD feeling that the operator itself would plug the well. So it'd be a little bit of relief potentially to some operators. I'm not sure how widely this would be used. Perhaps something to consider.
Commissioner Pullman, any thoughts?
Yeah, so looking at this, I do not have any objection to the additional language that NIMOGA is proposing, like Commissioner Bloom explained. And I think we had a lengthy discussion on this during the hearing. So I do not have any problems with regards to what NIMOGA is proposing, and I do not see anywhere that could be extensive conflict to what has already been proposed.
Perhaps the commissioners can help me. I understand it says discretion and waives, but seems like the green language proposed could very well swallow, if too widely exercised by in the future, could very well defeat and undermine a significant purpose of the rulemaking.
Mr. Chair, so just recalling what Commissioner Bloom said, assuming an operator is able to more or less come to a consensus with OCD that, let's say, the amount of money to bond is going to be used to plug that well. And I think OCD is the one going to implement this.
Mhm.
And I do not see the extent of the loophole you described. So I do feel like OCD will still implement this and they will have the discretion to really implement this rule. So I do not have any problems.
Mr. Chair, I believe we could also tighten this language up. For example, we have it read, or the division exercises its discretion and waives its financial assurance requirement because the operator is engaged in plugging operations for the well to be secured or will be within the next, say, 12 months
Okay.
period, and not have or for good causes determined by the division.
So more of we will take out the near future with a,
Something more specific.
yeah, more specific. $12 months. Okay.
If we adopt that language, I foresee a lot of requests for exercises of that level of discretion.
And OCD has the ultimate authority to either agree to that request or deny that request.
Yeah, I
So, Mr. Chair, if we had a horrible operator, there's a few of them out there, and it's the same ones we're always talking about. Some of those I think would be denied, but if it was a smaller operator, say limited resources, and had a cash bond of $150,000, they could take the 150 and apply it to the closing. If they didn't follow through on it, of course, OCD could take legal action, and I'm assuming that they would not be given that exemption in the future, or that variance in the future.
fair enough. I guess it's how much trust do I have in my future self and or my successors.
That's right.
And also how much I want to be, and how much the division wants to be. I don't want to use the word inundated, but this will be another layer of dispute that simply shifts. Whereas if it's categorical in the rule, there's less to litigate over. But whereas there's discretion, suddenly that could become highly contentious with multiple operators and multiple issues. So I think from an operational standpoint, I would rather not have more decisions to make. As much fun as this hearing has been, I would like to have, but reasonable minds may differ on that. So I see where you guys are coming from.
Mr. Chair, I mean, that's if you permit me, I think that's a real, and I noticed that Ms. Tripp has her hand raised, but let me just finish. We didn't, for example, hear testimony about what level of what the volume of variance requests could be, and then it could be a distraction, and it could be something that's very common, and then there has to be guidance put out on this and what that looks like, and forms put out, and maybe it's just, hey, P&A your well and your bond's released. So
I think it would certainly have more teeth if it didn't come with and I just didn't want to get, I guess that would be my concern, is whether or not this would end up having the decision bogged down in these discretionary requests. And I can see some operators taking a OCD decision or an exercise of its discretion and being okay with the decision, but I could also see certain cases where that becomes a very contentious and long process of trying to resolve that, and having cases stuck in a dispute over whether or not or how the division should exercise discretion in that context. So Commissioner, did you want to go first, or do we want to hear from Ms. Tripp?
Okay.
Ms. Tripp, did you have something procedural or?
Yes, thank you, Commissioner. I wasn't sure what order we're proceeding. There is an IP&M alternative proposed. It's at page 8 of that filing, I believe, in your books. So to the extent that you're considering similar language, I didn't know if you were moving through one and then the other, but I wanted to point that out.
Thank you, because I do want to make sure we're not missing anything. Thank you. Let me make sure we review that very quickly. Appreciate it.
Okay, so we don't have language here necessarily about a variance, but rather this additional language of other state level required financial assurance, et cetera, et cetera. And then down at the end, like with Namoga, we have language that they suggest would prevent double bonding. So, which would be our next discussion, I believe. So there's actually three different proposals here, one for variance, one for other state level required financial assurance, and then something else related to double bonding. So we can take these in turn.
Sure. Sure, let's take it in turn,
Perhaps we finish our
Sure.
discussion of
sure.
suggested variance language. And Mr. Chair, I hear your reticence here and would move that we do not adopt the additional Namoga language.
So I have a question.
Mhm.
So let's say if a well just tend to be a low producing well, right? And the operator wants to plug that well. Well, let's say there's OCD order. You have to take care of this. And the operator wants to use the money that you're going to use to bond that $150,000 to say that, okay, I want to plug this well with it. From what you were describing, I'm giving you probably 12 months within that 12 months to see if you plug the well. If you don't plug the well, then you have to bond that well. Is that not what discretion that the industry is requesting here?
Dr. Mpoma, I believe that is basically the discretion that Namoga was requesting, yes.
Without the
And-
12 months, but yes.
Yeah, without the 12 months.
Mhm.
So don't you believe that if we put that 12 months, then because they use near future, we are taking out the near future and then making sure that we have right timeline. Because I do see this happening a lot, where you have a well, no producing, you need to make a decision whether to pay $150,000 or you plug that well, probably 50,000 as an operator. So it's something that we should think about it.
Yes, no, I'm more than happy to engage in this discussion. It just would need to be a little bit more fleshed out, and because I would have questions around, well, what happens in 12 months if that well does not in fact get plugged? How do we enforce that? What is the penalty if they've gotten this, if somebody chooses not to bond and comes back every 12 months and says, oh yeah, I'll get to it the next 12 months. And remember, unfortunately, we don't necessarily have as many inspectors and people who can go out to as many of the wells as as many of us would hope for. So I know in the past, we've struggled with settlement agreements that require specific performance being hard to enforce when the specific enforcement hasn't necessarily happened in the field. So while I hear you, and I think it's a interesting point of contention, I don't know if this whole concept was sufficiently developed during the hearing. And
We talked about this because this one was more of one of the exemptions that the industry was requesting for. So I'm thinking that instead of saying near future, you just put 12 months. So you don't go beyond that. But here they are saying that because the operator is engaged in plug-in operations for that well to be secured. That is one. And then we can put something there to really stop it right at 12 months. So you cannot be coming back Because I do see from operator point of view, this is a big deal because you are going to be in that situation where you would have to make a decision. Yeah, and you do not want to go because here we have some stipulations where even one well in non-compliant state can put you in a really difficult situation. So let's look at it carefully and try and see if we can work my best to make it work.
Mr. Chair, I also, and Dr. Napoma, I also hear the commissioners or the chair's concern that what would happen if after 12 months that well's not bonded, then where do we roll that out in the rule? It sort of unleashes a chain of edits to the rule, a lot of which parties haven't spoken to.
But remember, it's a discretion of OCD. So I do believe that OCD do have the authority to more or less make some determinations on that. But I'm not making it so difficult, but I'm just trying to see if we can do something about this.
It's it does assuage me a little bit that the present tense is used in here if we were to go down, if we were to adopt this, that it is engaged. So the operator would have to be actively engaged in plugging operations, right? So it can't be something that is to be in the future for that well to be secured. So that does give me some level of pause. I just,
Mr. Chair.
I'm always a little weary to give a party discretion that they didn't ask for, but please.
Maybe the language could read, or the division exercises discretion and waives its financial assurance requirement because the operator is engaged in plugging operations for that well to be secured. And the well must be plugged, the well must be P&A'd within 12 months or bonded at that time. So we give them 12 months. But I don't know if that answers your questions about how many of these applications would the OCD get? Would it become unwieldy, nuisance?
The standards with under which the division would grant these or how the division exercises its discretion may become a litigated issue, as in how it makes these determinations. But fair enough. I see your point as to having some latitude here.
And Mr. Chair, if I might, I don't know if we'll finish before 5 today. There's some of these things we could set aside, think about,
Fair enough.
and return to, and sharpen up our pencils and see if there's language we might come up with over the next couple of days.
Okay. I certainly appreciate the thought that's being put into this, and I can see where I think I would just need to think about it a little bit, but why don't we tentatively I'll make a note that we are open to at least the language on discretionary financial assurance. And then there was a different question though that we need to answer, right?
There's 2 more. You take this one and then we could go back and look at IPA&Ms as well. Yeah.
So the last line in green is what we're looking at, right? Can somebody help me interpret what this last green line is attempting to do here? C through G.
The goal of this one is to make sure that, for my reading of NMOGA's intent here, and IPA&M, I believe, had the same language. We can go look at that when we look at their additional language. Would make sure that wells only have to be bonded once, so that if a couple of these categories apply to a well, that the bonds don't stack and become more than $150,000, might end up with a well requiring 2 bonds or something like that. I think it's a preemptive fix of a potential problem. Potentially. And if we're going to park something else, I might park this and come back to it. But there could be further discussion. I don't know if Dr. Mpoma has thoughts on this.
No, I do agree with you, Commissioner Bloom, on this.
Yeah, I would like to, I looked at it previously, but I'd like to take one more crack at
Reviewing it.
and seeing how, if there is possibility or potential for bonds to stack and multiple bonds to be required. Yeah.
Let's take so if we're gonna park this, then just the last, and we may park the IPNM proposals as well, but what is the IPNM?
So we're on page 8.
Binders though, where's the third binder? Oh, it's on the floor. Commissioner Mpoma?
Yeah, I would say that this is similar to what Nimoga is proposing to help prevent double bonding. So I think either one, but I see Nimoga's one is more direct. So
Yeah. So that's the last proposed amend, the last alternative, the last line and a half, is that exactly the same in?
Wait, hold on. No, it's okay. Yes. Satisfaction of any one subsection C through G for a well satisfies the operator's plugging financial terms. Obligations for the well. That's the same.
Okay, so that part's the same. So now it just comes back to that level. Okay. All right. So I think if we're parking both these issues, then we can come back.
I think we could take a minute and look at that one, just trying to understand where that goes.
Okay.
Let's take a look. This might be the waiver again.
Other state level required financial assurance. So other as in other agency, as in hypothetically state land office, or?
This is a waiver, so it says, or this requirement is waived in the discretion of the division for wells which are approved to be plugged and abandoned are subject to active plugging operations. So it's another take at that. And so we could park that and come back to it if we're looking to have this exemption or variance for wells that are nearing completion. You know, I think some people would, of course, P&A their wells and not want to pull the bond ahead of time, but I guess we don't know.
All right, well, I'm gonna reserve judgment and reserve a decision on 1915-89A as per request of the commissioners.
Mr. Chair, you then skip B and go to C. In C, applicants propose replacing the current one well financial assurance based on well depth with a flat amount of $150,000. This approximates doesn't quite meet, but approximates the current average cost for OCD to plug a well. And applicants also propose replacing the current tiered blanket bond amount based on the number of wells with a flat amount set at the statutory limit of $250,000. IPA&M did not propose separate language for 8.9C, but NMOGA did.
Use one of them for iPad and use this one for. Thanks.
Should I keep going? Oh, okay. NMOGA did, and the two major differences here are that NMOGA is proposing $75,000 per well, or the 25,000 plus $12 per foot. And also, instead of the blanket of $250,000, to go back to a little bit of the tier, $200,000 for 1 to 5 wells and $250,000 for more than 5 wells. So those would be the major challenges.
Commissioners, did you want to comment on that at all?
Yeah, Mr. Chair, so on this issue, I was expecting that the industry would have come in with experts, because I mean, they've plugged more, probably 90%, more than that, of the was plugged in the state. So I was expecting that it should come in with the experts showing us the numbers. You know, this is how much it cost us to plug our well. I mean, they got that opportunity, and I don't think they really followed through on that. OCD, on the other hand, the applicant, on the other hand, they showed us evidence. You know, they showed us, telling us that even there are wells that is probably 5,000 feet will cost probably $200,000 to plug that well. I mean, they showed us. You know, I was sitting here, I thought that it has to be tied to the well, but I mean, they tied to the depth, but they showed us with evidence that it's not really the case. So on this one, I will vote with the applicant and still keep that $150,000 bond. Thank you.
Mr. Chair, if you'll permit me.
Please.
Yeah, I would agree with Dr. Mpoma on this, and the preponderance of the evidence was OCD's testimony on this, the applicants talking about the average cost actually being $163,000. They rounded down to $150,000 per well. We heard testimony from OCD, from Mr. Powell, that well depth is not actually a good indicator of how much a well will cost to P&A. And again, we heard ample testimony that industry costs will be lower, because when industry is plugging their own wells and operators are plugging their own wells, they're typically responsible operators, and the ones that the OCD gets left with and that the bonds actually end up covering are the orphaned wells and wells that have been a long time inactive, TA'd, et cetera. So I believe that those are the correct amounts, and that we heard ample discussion of that throughout the hearing.
Thank you, commissioners. You guys took the words right out of my mouth. I think it's pretty clear from the record that the evidence here is much more robust, favoring we have a record here to support the numbers that the applicants proposed, and we don't really have anywhere near as strong of a record to support a different number here. The only debate in my mind would be whether or not to accept 150,000 as opposed to 163, which is what the evidence actually more strongly favors than 150. Please.
I'm sorry, Mr. Chair. One more thing. As I was reviewing it, NMOGA also invites the division to exercise their discretion again here by allowing operators to provide lots of documentation to them to justify a different amount.
I'll let the commissioners go first if they have thoughts, but I also have thoughts on that.
Mr. Chair, go ahead if you like.
It's just so NIMOGA and IPNM, they were presented with ample opportunities to really push that, to push this number two, what they are proposing, like an operator can propose a different one. I mean, they had the ample opportunity to really push that to the commission, but I did not have, in the records, I did not recollect any discussions on this subject for an alternative where an operator can really come in. I mean, they had that opportunity. They've plugged all these wells. They should have showed us the numbers, for us to compare. Thank you.
I take that point, and I will add, in addition to that point, that these are challenging decisions to make. And we've already spent a lot of time here at this commission trying to make a decision. To make an individualized operator by operator decision would be an administrative, would be administratively a nightmare. And I'm not sure that that's, and I'm also not sure that the administrative burdens of that was sufficiently, or how that might work in practice was sufficiently explored during the hearings if we were to go down that route.
Mr. Chair, I agree with you, and I would also agree with Dr. Ampoma that we did not hear, I don't think, any testimony related to this. So I would reject NIMOGA's suggested language here in 2, and then I guess I'll leave it there for now. But I'm not moved by 3 either. So thank you.
And we do have a raised hand on the platform.
I can't see who it is on the platform,
Oh,
but
sorry, it's
I will
Kyrie
take-
Bufa.
you're welcome to speak up.
May it please the commission, thank you so much. Kiri Buffa on behalf of the New Mexico Oil and Gas Association. I did just want to note our findings of fact 54 through 62 on pages 36 through 38 of our closing brief detail each of the instances where we had an industry expert testify in support of a $75,000 single well bond amount. And I just wanted to make sure I noted that, and if I might be able to add some color as to why we didn't include a protest
So,
procedure.
I'm going to interrupt.
Yes.
I appreciate that there's a lot of paper and there's a lot of different numbers, but we now got all the paper. Sheila
Okay.
got it. So we don't need any more comments from anyone in the audience where anything is, and certainly not testimony giving color.
Thank you. And I think to the extent that you were orienting us to paper here, I think we've got that. So thank you very much.
Mr. Chair, last one. So what NIMOGA is proposing right here is more like going to the depth tier system. And I think there was a lot of evidence to really counter that, right? So irrespective of whether there was 75,000 and then let's say 25,000 plus 4 or whatever it is, I think the applicant and OCD presented an enormous amount of evidence to prove that their number is what should be accepted. I think that was a centerpiece. And even all the commissioners, we asked all NIMOGA witnesses and IPNM, how much does it cost to plug your well? So irrespective of all the information that, let's say, we're going through here, I do believe that the applicant presented an enormous amount of evidence to prove that 150,000 is more or less the average number for OCD to plug wells that they are responsible for, not operator responsible for.
Mr. Chair, I think we heard from our counsel here, Mr. Chandler, that we won't have any more interventions here, but since NIMOGA got one in there under the wire, I did want to look at 54 and 62, and it was 57. Expert McGowan testified that 70,000 is a reasonable P&A cost. 58, regulatory expert Arthur plugged wells for 40 to 60,000. And then it kind of goes on to there. Representative Murphy said average P&A costs are approximately 100 to 120,000. Mr. Armstrong said 120,000. Mr. Purvis said 135,000 plus $2 per vertical foot. Of course, that was an expert for the applicants, but we see a range. I just think, as Dr. Mpoma said, ample testimony about the $150,000 figure. Again, we have this apples and oranges, where operator P&A wells are just different creatures than something that's been sitting out in the field and orphaned for a decade or decades. So just wanted to address that since it was raised.
Okay, so I was only looking at 1915 89 changes to 89C, but it feels like the discussion here addresses C and, well, all the subsections in D. Am I correct?
Well, so D and E are the two new financial assurance categories. D refers to what used to be called marginal wells, now low producing. We don't want to hurt their feelings, I guess. And E is related to the high risk portfolio, that is to say the number of inactive wells or TA wells. There, as you I'm certain remember, there's a flat amount for financial assurance for $150,000. I'm referring now to D specifically. The applicant's proposal removes low producing wells from the blanket bond financial assurance because they are high risk. You'll remember that industry argued that carving out low producing wells exceeded the commission's authority, that low producing wells still have plenty of potential, and operators of low producing wells should not be driven to plug them, which might result in waste. As a result of the post-hearing negotiations, there were some changes in the applicant's original proposal, which included providing a variance when there's a physical impediment, limiting the well's midstream takeaway capacity. They also delayed implementation of the financial assurance for low producing wells until May 1st, 2029.
Okay. Commissioners, do you want to go through this like C, D, D1, D2, or would you like to do this as a package? How would you like to debate or review these sections?
Now on the D, as we've discussed this extensively, I think the C, we are in agreement that, or probably we're leaning towards approving what the applicant is presenting to us. Now on the D, I think it's still the same thing. Nimoga wants us to go back to, or more or less, change the 150 to 75, which I think we did not agree to that.
Dr. Mpoma?
Yes, sir.
If you'll permit me, perhaps we would just take a minute to have a motion to approve C as per the applicant or the joint stipulation, and then we move to D.
Okay.
If we're ready for that.
Hopefully.
Mr. Chair, I move to approve section C of the joint application.
Seconded.
Any objections from commissioners? Without opposition, we will approve and adopt the language from the final the applicant's language for subsection C here. Okay, then on to subsection D.
Sorry, that was my fault. So the alternative language that you have for D includes both IPA&M and NMOGA.
Yes, and a couple things that stand out to me here. In D1, we have, well, into D, low producing, I'm fine with getting rid of marginal and going into low producing. But at the end of D1 here, we have NMOGA and I believe also IPNM wanting to strike one well plugging financial assurance. And I think that this resolves in D4, where we have an operator may furnish all necessary one well plugging financial assurance in the form of a single instrument. So we wouldn't call that a blanket financial assurance because we're already using that term elsewhere, but since it's like a multi-well financial assurance. So I think I would support leaving in one well on D1.
Right, so you support the language as proposed in the applicant's post-hearing proposed amendments, correct?
Yes, and I'm looking at NMOGA's language there as well, and they have, again, different, in D1, their D1 would offer different costs, $75,000 or $25,000 plus $12,000 per foot. So again, based on what we heard, I would not support those. I need to look at IPA&M here as well. Yeah. IPA&M change the language to say that is substantially out of compliance, which is different. As I think substantial is too broad and too baggy and too uncertain, would cause issues. Wouldn't support that. And 150,000 is struck to become reasonably sufficient. Again, I think we've agreed that the $150,000 figure is the correct one.
Mm-hmm.
And there's new language at the end that we should probably discuss separately. This provision shall apply to all other transferee operators 12 months from their effective date of amendment.
Mr. Chair, I concur with Commissioner Bloom on the number one. Thank you.
Yes, I also concur with, I think the record better support the language as proposed by this joint stipulation. For D and D1, do we have any other discussions on? Would you like to review D2 as well and accept them as package, or would you like to deliberate them separately?
D1, there's IPA&M language here, which is a little bit different, which is that this provision shall apply to all other transferee operators 12 months from the effective date of amendment. I'm wondering if that conflicts with transfer of well operator later on, where I thought that wells had to be bonded immediately upon change of operator. So I would not be in support of that.
Mm-hmm.
And as we go down later, if we see that that's not the case, we can come back and look at that. But I think at this point, no, I would not support that.
Okay, but you support the language then as proposed
In the joint stipulation, yes, for D1, absolutely.
Okay, so so in that case, would you like to move to approve the language proposed for D and D1 together?
Or you could keep.
Or do you want, all the
keep
subsections do
working.
D as a whole? Sure. Okay,
So then, the next thing we see here is D2 currently, and the joint stipulation has a start date of May 1st, and the IPA&M and NMOGA both say June 1st. June 1st, and I don't know if that month is significant in any way. Other than just giving someone an extra month. I don't know how that reverberates throughout the rule. I don't know if anyone else does.
It comes up twice, right?
I think it comes up quite a bit
Yeah.
later on as well.
Well, but just in this section, it's June.
Yeah, Commissioner Bloom. So on this one, if you recall, it was January 1, 2028. And we had a lot of back and forth on this matter. And even it was agreed that to give OCD more flexibility, because even January, then you are getting into session and legislative session. And so I will still agree to the May 1, 2029. I think that was what was discussed extensively. Even that was even 2028. And even they've moved it to 2029. So I'm not sure the June 1, how different that is. And no evidence was presented to that. So I will more or less agree to what has been discussed by all parties and then agreed on here.
The only thing I can think of for June 1st versus May is that it's aligns with the state fiscal year for purposes of reporting. That could make it slightly easier. So I don't have a dog in that fight, though I take Commission Council's caution that we try not to wordsmith too much. So I don't have a strong feeling either way, other than that June 1st could make reporting easier on a fiscal year basis as it aligns with the state's fiscal year. But I have no prejudice against the month of May either.
But that one is highlighted in green. Yeah, so definitely it was discussed between all the parties and they all agreed to that.
You mean it's highlighted in blue?
Blue, yeah,
Yes,
yeah.
okay.
My eyes.
Sorry, we'll, no, I think we can stay with May 1st. It sounds like there's a consensus around that. And then IPNM goes on to suggest that the assurance being an amount reasonably sufficient to plug the well. I would not be supportive of that language because it gets us away from the just straight up $150,000, puts the OCD in a position where it would have to determine bond amounts for every single well. And the MOGA.
Concur.
The MOGA also proposes alternate prices or levels, $75,000, et cetera, et cetera. So for the same reasons as in D1, I would oppose that. And they want to bring back the one well language, which I don't believe we need. So I would support D2 as it appears in the joint stipulation in the applicant's
Okay.
exhibit
Any,
89C.
any further debate on D2 before we move to D3?
No, thank you.
All right. Commissioners on D3.
I remember we discussed this extensively, and Commissioner Bloom, if you remember, we were talking about what are some of the options that we can discuss more or less to protect the operator, and I'm glad, I was very happy to see that all the parties were able to negotiate the three. To really more or less take into consideration any unforeseen events that the operator do not really have a lot of control. So I do support the number 3 that all the parties have worked hard to really come up with.
Yes, the joint stipulated language appears to have broader support than the other options in front of us.
I agree. Now, I think the continuation of this is there's a refinement of the nature of the variance that looks to be similar language between the MOGA and IPA&M. which goes on to elaborate what some of these reasons could be. We have that language in front of us here. I'm not going to read it all.
So just to be sure, is NEMOGA, what NEMOGA is proposing in addition to this, to the joint stipulated, language or?
Yes, this would be
Yes.
in addition. So this would be added.
Oh, okay.
It's in green font on their, yeah, exhibit.
So I
three.
see it right here,
Yeah.
just to be sure. Yeah, I believe that, the way they crafted the joint stipulation covers all the examples that NEMOGA is proposing here. Because it is on the operator to really demonstrate to OCD. So I believe that the joint stipulation is much broader than more or less going forward with, let's say, all the detailed language that NEMOGA is presenting. I believe that the joint stipulation still serve the same purposes as what NEMOGA is proposing.
Commissioner Mpoma, I would only note that NEMOGA adds an explanation in green, what do they call it? Emphasis language, that they suggest that the lack of takeaway capacity variance should also apply to transportation constraints. It was something they covered on the transcript there. But that's not what was stipulated to.
So as I look at these are things that we deal with course of our work at the land office as well. I don't believe I would have any issues with B through G. Well, B through F, but G is, an exception would be allowed for otherwise permitted by the provisions of the subject lease or approved by the SLO, BLM, or other governmental agency. That's a pretty big, that could be a pretty big hole. H is financial capability based on well economics, operational plans. So, getting an exemption to have a bond because the well economics aren't there means your well's not producing enough and it doesn't need to be bonded. I think that's a giant hole. I is interesting. No current market or the only market would require selling at a loss, which constitutes waste. That might make sense. Of course, people can request a shut-in. Any thoughts, commissioners?
I agree with your concerns about the loopholes being too potentially being wider than intended or acceptable. And also I go back to the fact that there's a wider range of broader range of support amongst the parties for the language from the joint stipulation.
Yeah. Perhaps a question for our hearing examiner or Mr. Chandler. This is new language. I don't believe we dealt with this in the course of the hearing. And yet, what we did have, 3 was a product of at least negotiations between the parties with OCD input. And for example, I don't know if OCD has read this, what they think about this. We haven't heard testimony on it. So perhaps for those reasons, I don't know if either Mr. Chandler or the hearing officer would like to weigh in at all.
So I can certainly look again through the proposed findings submitted by Namoga. My memory of the discussion, though, was that Namoga was inclined to seek exceptions for, how can I put this, a much broader category of force majeure or circumstances that might be characterized as force majeure.
Um, s- and I do believe that the joint stipulation is very broad, and I believe that it can cover most of the things that Nimoga is presenting here. So I'm not sure if it's duplicative, if we're adding this to that, or because the way Nimoga put it, they did not really touch on all the joint stipulation in this session. So it's a little bit difficult to see which one they do accept and which one they do not.
This was one of my concerns that I mentioned was I wish that, and I stated this, I think a number of times during the hearing, I didn't necessarily expect the parties to work together and collaborate, but I was disappointed that I didn't see other suggestions from IPA&M and Namoga. And, now here we are in final deliberations and we're looking at this.
Well, and if I can point back to the table reflecting the negotiated outcomes in the joint stipulation, I will point out that while Namoga does offer modifications for our consideration, it is noted that they do accept it. They do accept the joint stipulated proposed language with the fact that they are making suggested modifications. So I think the record will show that there is more, that the joint stipulated language for D3 has been more thoroughly vetted and discussed amongst the parties than other proposals in front of us, and that there would be more substantial party support, or at least less party opposition amongst the parties, and a stronger record to support the language in the joint stipulation.
Mr. Chair, I could agree with that.
Okay, having debated subsections D and then within D, D1, D2, and D3, is there any further debate on this? If not, would somebody like to propose that we accept the?
Oh, but wait, there's
Oh.
D4.
Oh, I apologize.
There's more. D4.
Oh, wait, there's more. Okay, D4, I apologize.
We have a number of D4s here. Yeah, the applicants in the joint stipulation have D4, an operator may furnish all necessary one well plugging financial assurance in the form of a single instrument. Now, Namoga, I think, got at that by striking the one well references throughout this section, but we've left those in. Namoga has a different D4, which I think you could save. I was getting hurt by a binder collapse up here before the end of the day. Okay, so Namoga's proposed D4, which says upon receipt of an operator's written variance request. So this could be like a D5 or something like that. Upon receipt of an operator's written variance request, the division shall have 30 days to accept or deny the operator's variance. If the division denies the variance, the operator shall have 30 days in which to file a request for hearing. Normal appeal and hearing procedures apply, and any such hearing shall be conducted pursuant to the procedures for the adjudicatory proceedings in 1915-4 NMAC. This might offer some clarity on how a variance request is handled. And this is pretty standard language, throughout NMAC. I remember working with this during the pit rule hearings back in the day.
Are you considering adopting both? So as instead of an alternative between the two
Yeah. Yes.
subsection fours that we adopt both?
That's right. I think we should consider Namoga's D4 as a potential D5. At least have that conversation. And IPNM does not have additional language on this, so clarifying.
Commissioner Bloom, that has to still be number 4, right? Because if you look at Nimoga new number 5, that is the number 4 for all the other ones. And that is more like the climax of all of it. So I think
You are correct.
yeah, that has to still be 5. I do not have any problem adapting Nimoga's number 4. Like you say in standard language. And it clarifies even the joint stipulation. So
I think, and Mr. Chair, I don't know if this is something you want to reflect on further. We could pin it, but this says that the operator shall have 30 days in which to file a request for hearing, and then it's in front of the division. And, I just don't know what sort of administrative burden is accompanied by this, but I don't know that 4 creates any more of a burden. It's, we've already done that potentially in 3.
Sure.
We've created the variance. So how does the variance get worked through? This is probably a good attempt at it.
As written, it's unclear to me what happens if the division fails to make a decision within 30 days. So, and it's neither a deem, accept, or denial. It's a vague language. So, let's put a pin in that. I just want to make sure that I can sort through and find substantial evidence to support adopting this if we go that route.
Yes, and I actually thought of that as well, that we might say, for example, no notification means that it was denied. And the division, that the operator shall have 30 days to file a request for hearing. So,
Right.
so we could fix it that way. I don't know that we're going to see support for this in the record. I think it's just come up now in a sense, but it would give OCD clear guidance on how to handle a variance request. Whereas currently, I would imagine that these sort of 30-day timelines would exist because it's similar to other things, but I don't know if there's somewhere else in statute that's a catch-all for how a variance is determined. Typically, I think each section has its own variance.
Commissioner Bloom, if I might, I've been looking at Nimoga's proposed findings and conclusions from 69 to 76, which addresses the force majeure language up above when you're applying for a variance. And I'm reminded that in the joint stipulation, the OCD did agree to create a guidance document confirming that low producing well variances are determined annually at the same time as low producing well status determinations are made, and that those variances continue for 1 year, but not indefinitely. So the joint stipulation did include that language aside from the language that you see in the rule. And I'm not seeing, for example, in proposed finding 75, that there is a reference to testimony supporting the variance language around 30 days to accept or deny.
I'm sorry, would you say that last part again? You did or didn't?
It's on page 40 of Nimoga's closing brief. with proposed findings and conclusions. I'm looking at page, I was looking all the way back to findings of fact 69, where they're talking about force majeure and how much more broadly they would read that than the other parties. A lot of which is repeated in this green font here in their post-hearing amendments document. So there's duplication there. But then in proposed finding 75, it says, NMOGA also proposes a procedure for protesting variance determinations as shown in closing exhibit 3. I don't see a reference there to testimony supporting that statement. Above, they refer to the discussion that was had between Commissioner Bloom and the witnesses about force majeure, but that's all.
May I propose to commissioners that we put a pin in D4 alongside the other provisions that we put a pin in earlier to have the night to review in more detail? And may I suggest that for now we approve the changes in D or from the beginning of D through D3 and reserve judgment on D4, or at least revisit it tomorrow.
Mr. Chair, I would so move.
Mr. Chair, I second.
Any opposition from commissioners? Without opposition? So decided on D through D3 with D4 to be reviewed tomorrow. Moving on to
Mr. Chair, what about the new the original D4? Now D5 from NMOGA.
let's review all of that together. So D4 and 5, so everything after D3 we can review tomorrow together.
But I thought that one was very simple, right?
Oh, sure.
Yeah.
Okay, if you would like to, sure.
Yeah, because as an operator may furnish all necessary one well plugin, NMOGA just strike out one well. And based on our previous agreements, I think I will not agree to the striking of one well.
Oh, sure. Okay.
This is the single instrument statement.
And just to clarify, you're proposing that we accept the language as drafted in the joint stipulation then?
Yes.
Okay. Commissioner Bloom,
Yes.
any opposition? Hearing no opposition from commissioners. The numbering is going to be complicated, but that provision was just discussed, is accepted by the commission. Okay. So now am I missing anything else if I move on to NMAC 1915-89E or Eric? If not, I invite commissioners on any debate.
Mr. Chair, I would note that originally this, I believe, was a 15% threshold. It was moved to 20% after negotiations between the parties. And I'll take a look and see if there's any alternative language suggested by IPA&M or NMOGA. And there is.
For E1, but just E, is there any?
Oh, for E, no.
Okay.
No. So I guess we could go maybe perhaps move to E1.
Okay,
And on E1, I think we've covered this terrain already. We're faced with the choice of the May 1 date or the June 1 date. We elected May 1st. And then also there's the one well strikeout, which we have previously denied. And then the amount would change from 150,000 to reasonably sufficient to plug the well covered by the financial assurance, which would leave OCD in that position to having to determine the adequate bond for each well, which we have decided against. So let me take a look at Nemoga. Anybody else has comments?
If I recall correctly, we had on the question of, I mean, we already decided that 150K is going to be administratively far more efficient, but I believe there was a witness on behalf of, can't recall whether it was IPNM or Nemoga, but there was an economist who agreed with me on the witness stand that trying to figure the appropriate bonding on a well-by-well basis, the transaction costs of that would outweigh the benefit.
I think that's an important addition. And of course, we have discussed multiple times now, sort of the apples and oranges nature of the cost of P&A for a well. I've looked at Nemoga's language also here, and well, a little bit different from IPNM's. Again, it would abandon the $150,000 bonding amount for the $75,000 plus X amount per foot or something along those lines. So again, something we've seen and rejected. And then also the one well language and the June language, which we have previously rejected.
And I believe the same comments around the one well, I mean, that applies to E2 as well, right?
Yes, but IPANM has some additional language there also. They put in $1 million cap. Maybe we should finish with one first and see if we want to adopt that, or if there's any further discussion on it, we can adopt them all together.
I do not have further comments on E1. Dr. Mpoma?
No, I do not. Thank you.
E2 then?
So on E2, Nemoga proposes striking one well, which we have denied. In 2, IPNM says would it add the additional language, any operator whose total plugging financial assurance for active oil and gas wells, whether required under subpart C, D, E herein will exceed 1 million as of June 1, 2029, may apply for a variance pursuant to subpart D3 or the alternative, contribute 3% of additional financial assurance required under subparts D and E annually to the reclamation fund. So this would certainly lower the impact on oil and gas operators, but then there could be variances after $1 million or contributions to the reclamation fund. It's my recollection, we did not discuss that sort of proposal. I don't know if I've seen that language before. Of course, I didn't see it in my preparations. I could be wrong. But in general, I would not be supportive of that, as it really undermines the vast bulk of the applicant's proposal in the joint stipulation.
Commissioner Mpoma, any thoughts?
Commissioner Bloom, I'm not. So did you read like the E2? Was that what you just read? E2?
Yes, that was IPANM suggested. Thank you. That was IPANM suggested in addition to E2. I'll pass this down for you. One second.
Here, right?
Yeah.
think it's still there. Still there.
I think for my part, I concur, but if, would you mind reiterating?
Sure, and perhaps we'll take a 3 o'clock break for a cup of coffee and maybe a bathroom break. Starting to slur my words up here. Mr. Chair, so IPA&M's suggested additional language here
Yes.
would essentially allow for a variance if someone's bonds went over $1 million total as of June 1, 2029, or alternatively, that operator could contribute 3% of the additional financial insurance required for subparts D and E annually to the reclamation fund.
Mhm. Yeah.
To me, that's a new proposal. I did not recall that being discussed at all or at length or hearing testimony on that. It really creates a new approach to bonding that's very different from where the applicants were going and what we see within the joint stipulation. And so for those reasons, I would deny that language. I think we have more support, good support for the applicant's joint stipulation.
I agree. Thank you.
Mr. Chair, I could offer from the findings and conclusions, other than from IPA&M, that by negotiating from 15% to 20% of the portfolio, that provision would apply to 13% of the wells in the state.
Okay. I think,
Yeah. Oh, I was just going to say thank you, Ms. Worth, for that. Right. So when we go from 15 to 20%, less wells are included. It gives folks a little more breathing room if they have more wells that are in those categories. Yes.
yes, and I think Commissioner Bloom, your point as to what has broader support amongst the other parties, looking at the language here in the joint stipulation that every party, including NMOGA and IPA&M, got to discuss. I'm seeing that all parties would be able to accept, even reservingly with all the reservations and whatnot taken into account. So I think your point that the language in the joint stipulation would have had more vetting and would have broader support amongst the parties in front of us today stands.
I agree. Thank you.
Okay. Any further debate on subsection E?
Now, Mr. Chair, I would have moved to adopt the language that we see in the applicant's joint stipulation.
Or subsection E?
I support. Yeah.
Great. Any objections? Without opposition from commissioners, so adopted for subsection E. Okay. Let me look at real quick. You want to finish this NMAC before we take a break?
Maybe we look at F, which is a little bit similar, and then we take a break before 8, G and H, which are, I think we can do G, but just take a break before H, which gets into consumer price index.
Okay.
The math.
1915-89F. Debate. Thoughts, commissioners?
Mr. Chair, so here NMOGA is proposing that we strike out. So inactive wells, so we have and wells in approved and expired or approved temporarily abandoned status for more than 2 years. So we discussed this extensively. And I tend to agree with Nimoga because I'm wondering why a well that is in approved status, that 2 years more or less give them that room to be able to more or less put that well to a beneficial use. So why should we more or less bond that well at a very high amount? So I'm leaning towards striking the approved wells and then keeping the expired. So that'll be my comment for now.
Commissioner Bloom, any thoughts?
Dr. Poma, could you explain to me again the difference between these two? Starting to look like a word salad. I mean, I'm just at that point, but so we have in the applicant's petition was to read inactive wells and wells in approved and expired TA status, but then Nimoga would suggest wells in expired or approved. It seems like they're just reversing the words. So I think the difference, right, is that they're adding more than 2 years.
So essentially, they are saying that the approved temporarily abandoned wells, the approved ones, you have to give them 2 years before you ask them to provide the new bonding.
Yeah. Okay.
Mhm.
Okay. Let me digest that. So am I right that the wells in TA status, the first 5 years, they're exempt from the bond coverage, correct? And then there's another 2-year period and another 2-year extension?
I'll probably need some recollection on that, but
Yeah.
essentially what this provision, the applicant wants all wells in TA status to be bonded, same as expired, putting them at 150,000.
So I think what this gets back to is that the conversation we had originally that goes back to Mr. Rankin's rainbow, the last sentence there that says, just have to go back to that. 70-2-14. The last sentence says the Oil Conservation Division shall require a one well financial assurance on any well that has been held in temporary abandoned status for more than 2 years.
Mhm.
And what the opponents have proposed is actually requiring that without that 2-year exemption.
Exactly.
So that this actually ties back in here as well. I think we said at the beginning, we were supportive of creating a new category of bond, which is one that requires a one well financial assurance, even in the beginning of that time. I don't know if Mr. Chair wanted to weigh in on this. It could also be something we come back to, just going through these things one more time.
Sure. I prefer the joint stipulated language here, because again, for, again, there's broader support, right? Because NMOGA, despite proposing an alternative, NMOGA and IPNM both say that they are able to live with, even if they don't like it, that they are able to live with the negotiated stipulated language. Temporary abandonment is also fairly easy to get. And from my perspective, it appears to me that temporarily abandoned wells nevertheless remain risky of being fully abandoned. And they are lower producing wells by practically by definition. So I don't know that there has been sufficient evidence in the record that would convince me to adopt the alternative. I think it's the MOGAs.
Mr. Chair, so we had a lot of discussion on this subject. So as I mean, like, let's say you are putting this well TAA, so you start enhanced oil recovery. Now, if we are not giving that 2-year room, it sounds to me that we are prematurely plugging wells that could be utilized for enhanced oil recovery. We had a lot of discussion on this matter. So I'm not sure why we should treat expired TA wells same as approved TA wells right from the onset. I'm not sure why we should treat them all the same. And we had a lot of discussion on this matter. This bonding a well at $150,000 is not an easy number. And I do believe that we will push wells that could be utilized for enhanced oil recovery to shut down, or let's say to be plugged prematurely. So that is where I'm coming from.
I'm not sure that I agree with that position, but I'm happy to continue the debate, Mr. Commissioner Bloom.
Yeah, Dr. Napoma, I did see your comments about this again in people's closing statements. So I do hear your concern there. I think at this point I'd ask that, and we've done this in the past and deliberations, put a pin in this here, take some time, and I just want to understand again so I can't put my fingers on it right now. The current bonding rules for TA wells. So just want to make sure that I understand when currently those are bonded and how that would change in this new world. That's all right with you all.
And Mr. Chair, I do have a question for you though. So what is the incentive for people to have approved TA compared to expired TA? If let's say, if the direction where you want us to go, what will be the motivation for? Because before you get approved TA, you have to show that it meets mechanical integrity test, right? So you made mention that those wells are more susceptible to more like failure and all of that, but those wells need to pass MIT before they are given the approved TA. So there has to be some kind of support for that, other than companies will, okay, expired TA, I don't need to, yeah, and then I'll just leave it as that. So something for us to think about.
I appreciate that, and I will get back to you. I will think about it and get back to you. I think we're probably at a point where thinking won't happen without some coffee. So, so if it's all right with commissioners, I propose that we put a pin in the conversation and take a break at this point. 3:20 or 3:30, 3:20? Can we come back at 3:20? Okay. Any opposition to taking a recess? None?
No.
All right. Okay. Good afternoon, welcome back. We're back on, calling the meeting back to order on to continue deliberations on WELC application for rulemaking to amend, NMAX 1915-2, 5, 8, 9, and 25. All right. I think we are, if I recall correctly, we'll come back on, I want to see if we can get through what issues are, non-controversial or the commission has all agreed. And then that way we can have a day to come back and gather all of our thoughts on provisions where there might need to be more discussion and deliberations. So where are we on NMAC 1915-8-9H? I'm sorry, G and H.
Yeah, I think even for the F, maybe 1, 2, I think probably it's more similar to what we've dealt with before. Unless you just want to table that for, let's say on Friday, that is fine, but
Yeah.
other than, okay. That's well, okay.
Well, let's come back and discuss F on Friday.
Okay.
Any debate on, I'll give people a second to
Yeah.
pull up where we're at.
So let's see, we're on G now.
Mhm.
So this adjusts for the new rulemaking. We see that this allows a single instrument to be used versus using the language of replacement blanket bond, which I think caused confusion with the previous 250,000 or the previously existing $250,000 blanket bond, which still exists. See what Namoga says about this in IPANM.
There's for well, paragraph, what would be paragraph G in the applicant's final proposed amendments, and what is, I believe it's E in Namoga. Namoga proposes 2 additional words, and in green. Yeah.
Mr. Chair, is that a legal term?
I suppose so.
Then I'll defer that to you.
I mean, it already says limitations, so I'm not sure that I feel strongly that I see the need for that particular wordsmithing there. I'm fine with the language as proposed in the applicants, but I will entertain debate or contrary opinions on that.
Yep. I think this went through, a meeting, many meetings of the parties, and at that point, people were good with limitations, and I would be fine with that here.
I think the limitations works pretty well. Adding the rights, I don't see how it changes this. So I will also agree to what the applicant is proposing here. Thank you.
Okay. Any opposition to the language as proposed by the applicants for subsection G? Which G? No, right? Because I think that's what we just said.
Yes.
Okay. Without opposition, fair enough. So now on to what is numbered H in the applicant's post-hearing proposed amendments. There is some disagreement between the parties on this as well. There is some green text in Namoga's version.
I do have a question for my fellow commissioners. So this provision is more of OCD would have to review the financial cost, the financial assurance cost. Could this number be lower than the 150,000?
Mr. Chair, Dr. Poma, I believe no. Towards the middle, it says any financial assurance shall not be adjusted below the minimum amounts required in the subsections as a result of a decrease in the consumer price index. Does that answer your question?
Yeah, I've thought about this. And I don't recall if there was an extensive discussion in the record. But I was just thinking aloud that the cost to plug a well, the financial assurance should be the amount that OCD will more or less use to plug a well. So does OCD not need to consider, let's say within that the time period, how much it costs them to actually plug their well? And with that, include that in fixing what the next cost should be, other than just setting more like, we're going to probably increase to this amount without going back to how much does it cost OCD to plug a well? That's just a question I have for the commission.
So Dr. Poma, your question is, should the base amount always be $150,000 or should that be periodically updated? Or did I just put words in your mouth, Dr. Poma? I'm sorry.
No, what I'm saying is that, so you have the base amount, but I'm asking if, let's say, after several years, definitely the cost might go up, but advancement of technology, cost might come down, so, or even operators might end up plugging their wells and OCD will not even plug any company's wells. So I'm just asking, should there not be a situation where OCD has to also factor in the adjustment how much it costs OCD to plug their well within that time frame?
Sure.
So if I could just clarify, I believe your question is whether or not the consumer price index is an appropriate proxy for costs to plug into the future, and whether the consumer price index is calculated in a way that is sufficiently reflective of the specific well plugging costs.
Exactly. Thank you.
Well, that's, I think, a policy decision for this body to make.
Yes, and I think we heard some testimony on that, and I'm very comfortable with the proposed language here. I think because of the some of the pushed back dates here, there'll actually be a bit of a price break for industry because certain increases are not happening until now 2032 instead of 2028. So inflation is going to take a bite out of the actual value of the $150,000 bond before it starts to rise again. Dr. Mpoma, to your question, I think, if suddenly there's crews of robots out there and they're plugging wells with cement printers or something like that, and the price, seriously falls, then I think it's unfortunately at this point, people would have to come back and petition again the OCC. Look at that. We don't have something in there that says, every 5 years, the OCD shall recalculate costs, the average price to P&A a well, for better or for worse. So, this kind of locks it in.
Thank you for the clarification. So with that, then I do not have any problem with what the applicant is proposing here. Thank you.
So, yeah. And so I would just add that I don't see differing IP&M language here, but NMOGA does have some minor changes made, and they line out, for example, some of the subsections, and what that's getting at is, I believe their position that some of these bonds cannot be pinned to CPI. And I went through the record and looked at that, and I think it was OCD talked about that's a pretty standard part of what, it exists elsewhere. It's a power that OCD already has to adjust by CPI and other agencies and so on. So I feel fine with the language here.
I broadly concur, I generally concur with Commissioner Bloom. Is there any further debate on this section?
No, Mr. Chair.
Is the Commissioner Bloom, are you moving to accept?
I would move to accept, Mr. Chair. Or a second?
I second.
Okay, so and that would be the applicant's proposed language, the final proposed language for 1915-89H. Is that correct?
Correct.
Okay. There's a change in 1915-810.
Yes, and this, looking at some of the testimony on this, the reputable companies that are listed by the Department of Treasury and Circular 570 are generally or considered reputable corporate surety companies. And this is pretty common in government and business. And I think we heard testimony on that. NMOGA seeks in its draft to line this out, but I'm comfortable based on what I've seen throughout the hearing that this is fine.
Mr. Chair, I agree with that. Definitely, we should leave that provision in there. Thank you.
Okay. Is there a motion then, or just the commission wish to approve the proposed language in 1915-810?
Yes.
I second.
Any opposition? No opposition. The next change that I see, and correct me if I'm wrong, but the next change that for the commission's review is in 1915-812B. This was addressed in the joint stipulation. See if there's. There is, well, the NMOGA proposal is to not include the change, if I read this correctly. And I'll invite any debate.
I'm not sure I'm seeing that. Let me look at your version.
This line right here. And the NMOGA basically green strikes it back up.
Yeah.
So, yeah.
Can you just language?
Yeah. Is there any record reflecting why they believe that should be cancelled? I'm trying to read through that, but.
I will note that if I'm looking at the table for the joint stipulation, that it's generally satisfactory to WELC, OCD, SLO, OCC. And while NMOGA and IPNM reserve legal arguments, that they're generally able to live with the proposal. So
Let me add, if I may, Mr. Chair.
please.
So I think if we no, I'd actually need to go down and scroll down to look at 1915-99. See what that is. Refresh my memory. So that's change of operator. So yeah, I think this has to stand because it's actually part of the overall changes. So
I would agree.
No objections. Thank you.
Okay, commission is satisfied with the language as proposed in um, the applicant's final proposed amendments for 1915-812.
Yes, I would move to adopt that.
Seconded.
Any opposition? Without opposition, so accepted. I think that brings us to the end of 1915. Brings us to the end of 1915-8, correct? Okay. So proposed changes to 1915-9,
Do you want a few words, Mr. Chair?
please.
So the rule revisions are designed to ensure that new operators seeking authority to operate and existing operators acquiring new assets in New Mexico do not have a history of financial assurance forfeitures in other states. The applicants OCD and OXY did revise that language as part of the stipulation to address concerns that the original language was too broad and would tee up administrative challenges. They also revised some of the well operator provisions to allow a representative designated by the operator to make the forfeiture and compliance certification, so that operators have discretion to determine who they deem fit to be held accountable for those certifications. Also, changes were made to base certification, denial of registration on final administrative forfeiture demands, and the look back period of 10 years was also changed. NMOGA's proposed findings would have you focus instead on statements like the record reflects no evidence that existing Part 9 requirements have caused compliance failures or impeded OCD's ability to enforce operator obligations. And Mr. Powell testified that the Form C-145 language is not an outgrowth there. It's actually contingent on Part 27. They believe the compliance certification is overly broad and not supported by substantial evidence. All of that is found in NMOGA's findings 123 through 132. You do have proposed language by NMOGA starting in their Exhibit 4. And you also have proposed language from IPA&M.
Okay, let's start with 1915-9-8B. Thoughts from commissioners?
Mr. Chair, I see, I think we had quite a bit of testimony on operator registration, change of operator essentially. And this is a way to make sure that bad operators aren't starting up in the state or coming into the state. And it looks to me like IP&M's language here is quite similar to what we're seeing from in the joint stipulation. But NMOGA would line out about the last half of this where it starts to look at, disclosure of any officer, director, or person that has 25% control, language along those lines. I thought there was good support for maintaining that language. Obviously, the OCD is part of the joint stipulation and felt that this was manageable. So I'm comfortable with the proposal that we see in the joint stipulation for 8B.
No, I do not have much different thoughts on this. So I will support Commissioner Bloom's submission. Thank you.
I also broadly support Commissioner Bloom's comments here. This seems to be a significant, an important move towards ensuring that anybody, making sure that we're not having operators who are undercapitalized or somebody who has a history of financial forfeitures and operating in a way in the state that creates a public a problem for the public. I'm comfortable with the proposed the post-hearing amendments as proposed by the applicants for subsection B. Is there any contrary thoughts?
Mr. Chair, I'd move to adopt.
Mr. Chair, second.
Any opposed? Without opposition, B is adopted. As proposed by the applicant's post-hearing final proposed language. Subsection C. Any concerns from commissioners?
So, Mr. Chair, the suggestion from DeMoga, but not from IPA&M, is that the 10 years be made 5 years here. But 10 years was agreed to in the joint stipulation. So I would be comfortable with that.
Yeah, I also support that because even on the first one that we just talked about, we still agreed to the 10 years. Thank you.
Okay.
And then, Mr. Chair, I think we could go down to the new 5 without any problem. There's no change there.
The new
or disagreement. Yes.
Oh,
C5.
I see.
The new C5, yeah. There's no suggested different language from IPA&M or NMOGA. So I would suggest we could adopt at this time 1915 9C2 and C5. And then we might look separately at E, which does draw some different language.
Okay, so we're adopting 1915-98C in its entirety, correct?
Correct.
Yes. Yes.
Okay. Any opposition to adopting 1915-98C? Hearing no opposition, 1915-98C is adopted. So new 1915-98E. Any debate?
So, Mr. Chair, here we have NMOGA lining out number of spots, 3 different spots. So you might want to look at that. Everybody in the language in front of you. I might want to walk this backwards. C2 and C3 up above, which NMOGA would rule out. And let me check IPA&M on this.
I mean, this is tied to the previous sections. This is making it mandatory that an operator shall certify compliance as opposed to using the permissive may language, swapping may to shall. And to make it consistent with the new, with C.
So, Mr. Chair, on the E,
Mhm.
so Nimoga is saying that the division may require.
Which is the former language, yeah.
Yeah. So does that not, I mean, does that not help? I'm thinking about operator who is more compliance,
Mhm.
with no record. Why should they be doing that every year? So is it not, that not be a discretion of OCD to more or less require? So I feel like, yeah, let's really discuss more of what Animoga is proposing here.
Sure. So in my view, if we make it a may
Mhm.
instead of a shall, then you undercut it makes it more difficult to enforce the new provisions in C that we just adopted. So it's by mandating annual certification, instead of OCD having to go out there and figure out who needs to certify, it puts the onus on the operator to certify on an annual basis. That's my understanding.
That is my understanding as well. Yes. And so I would imagine that OCD would create a form when they're creating their guidance, and companies would use that and certify themselves. And Commissioners, I apologize. I may have missed something when just up above. I can't remember if I said IPN, if IPAN had different language or not, but I believe actually they coincided with Nimoga in a lot of the lineouts in 9.8 B and C, which we were looking at. I don't know if you care to go back and look at that. It was, I think, nearly identical. We might want to finish with this first.
Yep.
I just wanted to mention that.
Having reviewed both, having reviewed the alternatives proposed here, I'm still comfortable with subsection E as proposed in the applicant's post-hearing.
Yes, as in mine, I would move to adopt that.
Seconded.
Any opposition? Adopted without opposition. Okay. 1959-9B. Is a significant portion that the applicant proposes that would not be adopted in the Nimoga proposal.
And that is the same, and there's also a significant line out in IPANM's proposal as well.
Mr. Chair, so on this one, I'm not sure why the industry will strike down a plug-in and abandonment plan. I believe it's very important. And then also, if we do not agree to what the applicant is presenting here, then it means that we still have to go back to the earlier portions where we are requesting for the directors and then people with that stake. So if we've approved that one, then I do not have any reason to reject this. Thank you.
Yes, I would. The two provisions that Commissioner Mpoma is referencing do correlate, so I agree on that point.
I coincide, I would move to adopt 19.15.9.9 B as seen in the joint stipulation.
Okay, applicant's final.
Seconded. Thank you.
Any opposition? Without opposition, so adopted. 19, 15, 9, 9, wait. We just did 99B, so 99C. Again, this is a corresponding section to all of the above, so. And the same policy and the same. The same overarching issues resonate through.
Yes, Mr. Chair, exactly. I see the line outs proposed by IPA&M and NMOGA here, and they're very similar to proposed line outs up above with respect to the roles of operator, officers, et cetera, previous companies. I think significantly the language here is that the director's designee may deny a change of operators. Doesn't mean that any of these things are would disallow change of operator. So, but and I also see down in 5 we added limited liability, limited partnership, which is important. So I would recommend adopting 1915.99 C2. We see it in the applicant's final version of the joint stipulation.
Okay, what about C3, 4, 5, and 6?
And I would, yes, and I would adopt those as well. I should have said all of C. Yes.
Okay.
No objection. Thank you.
No objections from me. Any objections from commissioners?
No.
Okay, without objection. Adopted. And just for the record, I will note that we had a discussion about the legality of looking to other states and federal agencies as to whether or not there's been forfeiture of financial assurance. And I just want to recall the conversation that I had with the witness who, being licensed and being a licensed attorney, most of us who are licensed to practice law have to report if we're ever disbarred by any other state. So it would be the same logic here that if what we would have to report compliance with all states where one operates. So E, any debate on E?
Mr. Chair, I would just note that in D, there are also some lineouts.
Oh, I
But
apologize.
they appear in black, which is
That's right.
different.
D.
We can look at D and E together. Yeah.
Translation. Who comes with that?
D. So it's whether or not to remove the words more than the allowed number of.
And Nimoga wants to bring it back, so.
Yes.
So, Mr. Chair, we cannot agree to this because if you remember, we did not agree to Nimoga argument about trying to, no, I think, are we tabling that for future discussion or? Where he was talking about 2 wells out of 50%. I think we did not agree to that.
I don't know that we've touched
Yeah.
on that, Dr.
Because that is connected to this. So if we can cross-check that.
Okay. In order to keep the day moving along, why don't we do the cross-checking and research
Yeah.
over the evening? So I will make a note that we will review 1915-99B.
Did not agree.
Very well.
Mr. Chair, I believe we did not agree to what Nimoga was proposing right here. So they're coming back. Yeah.
1915.
You can check that.
1915.
5.9.
That's right. Okay. In that case, is it your proposal that we adopt the applicant's proposed final language
Yeah,
as written?
the strikeout. Yes, it has to stand. Yes.
Okay.
Thank you.
Mr. Chair, I might want some more time to review that.
That's fine.
Okay.
Well,
Thank you. If you indulge me, Dr. Mpoma, thank you.
sure. What about E?
Mr. Chair, so this one was discussed because based on the discussions that we're having, it sounds like big companies that do have the muscle to really plug these wells will transfer these wells to smaller operators who will not be in the position to really plug these wells. So I believe we were more inclined to really go after the bad actors, right? So I believe this E has to stand in the sense that it protects, the state where the wells will not fall into smaller operators that will not be able to really plug these wells. So I support that this E provision has to stay in the rule.
Mr. Chair, I would concur. Additionally, just to note that Part 29 refers to releases or spills, and Part 30 refers to remediation. So this is essentially saying you can't transfer a well facility or site to another company unless it's been brought into compliance or the new operator submits a schedule of compliance. It's been approved by the division. So this seems common sense. We're not, so that we get away from any sort of pass the trash situation.
I concur.
So I would move to adopt 1915-99E in the joint stipulation in the applicant's steering amendments.
I second, Mr. Chair.
Any opposition? Without opposition, so adopted. Okay. I don't see any further additional changes to 1915-9 nine. Or, yeah, I don't see any additional changes to 1915-9. Is that correct? Anybody else see something that I don't?
Yeah.
Okay. Moving on then to 1915. 1915-25. First change that I see, well, almost right away. 1915-25, 8A, B, 8B.
Mr. Chair, just a reminder, this is the section where OCC, having stipulated to a lot of the applicant's other provisions, does have recommended changes here.
Great.
And just a question, I don't know if anyone else is seeing this. I don't see any proposed alternate language from IPA&M in this section. Is that right?
That's correct. We have finished the proposed IPA&M language.
Okay, and we will get, thank you, Mr. Chandler, reminds us that there's OXI's final proposed amendments to Part 25. When we hit 13C, so.
Right, did somebody have a spare copy of? Let me make sure I pull up and tab OXI's proposed changes so we can go through that.
I have it here. We can share if you like.
Yeah, that one is 13, right?
Yes. I have extra one here.
Not the proposed finding of fact, but
Happens here
okay,
between.
yeah, if I could just have a copy, that'd be good. Now I've lost my place in the original. Did you have other overarching thoughts for us, Madam Hearing Officer?
No, not really. It's relates to the section, the part relates to plugging and abandonment. Applicants propose to reduce the current 90-day timeline to either plug or abandon a well or place it in approved TA for 30 days. Industry witnesses testified that the 30-day timeline was unreasonable. Applicants revised the well operator provisions in the post-hearing amendments to provide a 60-day timeline to either plug or abandon or place it in TA. Retain the requirement that the 1-year period of inactivity be continuous. Trying to strike a balance there. Do I understand correctly that y'all already reached some conclusion about the presumption of no beneficial use this morning?
We included that, the definition, Madam Chair, or Madam
Oh.
Examiner.
Okay, well, in 25.9 is where it comes into play.
Yes. All right.
Well, starting with, let's just.
Part 25, 8B,
Yeah, let's do that.
1, yeah.
Or eight,
yeah,
8B unnumbered, yeah.
1 and 3, yes. I noticed that we have no different language from NMOGA nor IPA&M here. And, I think we've seen some changes, some compromise. And I would say that there are other changes compromises that I'm accepting here. I think that as we're looking at like a 3-year implementation deadline, if I'm not mistaken, or timeline, I think that's very generous. Maybe 2 years would have been in order, or 18 months, but we're going 3 years. That's what the parties agreed to. And I can live with that out of that spirit of compromise. That's elsewhere. I think in the document, we've probably already gone over it. I did want to note that. And I note that the OCD was part of those, those conversations as well. And I think that's significant when the agency or the division that is going to implement any rulemaking thinks that 3 years is appropriate. Could be for their own interior timelines and necessities as well. So something I can live with here. I think these additions are great. That, except for a well that has been drilled and properly cased but not completed. So you're getting at the ducts, the drilled not completed wells or uncompleted wells. So I think all this looks good. We don't see any other competing language. So I would move to adopt the changes to Part 25(8)(b) 1, 2, and 3.
No objections.
Okay. Question is whether to adopt 19-15-25(8) and all the changes as in the applicant's post-hearing proposed final amendments. Any objections?
None.
With no objections, so adopted. 19-15-25(9). Namoga has some commentary or thought commentary in their proposed rule here in italics about the presumption of no beneficial use, and also proposed amendments should the commission proceed.
Yes, Mr. Chair, my understanding of this is looks to me like Namoga does not have language that is different. I'm kind of jumping pages here. Yep, okay. So not till we get down to, I guess, in D, D itself, the change. Okay. Namoga's language would, I think it's pretty clear here. The division may use its discretion to grant another 30-day extension after the notice for good cause. If you two have any thoughts on that, commissioners?
So this will be the D, right?
Yes.
Okay. Yeah, so on that one, I do not have any objection to what Namoga is requesting here. But I'm curious to know what you all think about this.
I'm always a little weary when a party is given discretion that it didn't ask for, but do we want to break this down into smaller subsections one at a time?
If we were doing that, I think I would agree with Part 25.9 A, B, and C as proposed, given that there's some unanimity around the that language, although of course Namoga and I believe IPNM, of course, think this is an overstep and would challenge it on that potentially. But
Well,
I think the real first change or disagreement we're seeing in D, and the only change would be to give the party 60 days instead of 30. In the case that a party does ask for more time.
I'm always, I mean, my only hesitation there is again, just more decision points and more potential things that just division staff have to make decisions on. It already says grant an extension, but if we were to adopt the green here, my only ask is that we make it grant one extension so that we don't have potential later argument of repeated 30-day extensions.
Mr. Chair, I will agree with you.
I'd be fine with that, Mr. Chair. I 30 days can be short if it's November, December, January session, February. So an extra 30 days, I don't think would cause too much difficulty, and limiting that to one 30-day extension would be fine.
Okay. What about so that we can consider D as a whole? What are the thoughts on subsections 3, 4, and 5 below that NMOGA does not agree to?
Mr. Chair, I think I would not adopt NMOGA's language here because there's been another change made up at the beginning before the enumerated parts. We see such documentation may include, and so that just means that the applicant may include these other aspects, including that they, maintain adequate capitalization or revenue sufficient.
This is merely an illustrative list. I mean, the way it's written now with may include, it merely means that the list is illustrative and not. Yeah. Yes.
Okay.
So is it the commission's desire to adopt the for 1915-25 9D to adopt language as proposed by the applicants, except with the inclusion of upon request by the operator, the division may use its discretion to grant one extension of the grant one 30-day rebuttal period extension for good cause. Kind of have to reword it a little bit for
Instead of and, it would be one.
Or
Yeah.
one 30-day or grant an extension. I guess an extension makes clear that it's one, so fine. Is that what the commission wants to do? So accept the applicant's proposed language with the one additional sentence from NMOGA's proposed language?
Yes, Mr. Chair.
Seconded.
Any opposed? Without opposition? Okay. I'm lost my place again.
We're down to E, 12 months become effective.
I have no objection other than that somebody has to fill in the effective date of this.
So this is interesting. So I wonder if this actually needs to generate conversation, because it says the subsection shall become effective 12 months after the effective date of the rule, except that as to operators that the division determines are substantially out of compliance, parts 24, 9, and 25, This subsection shall become effective on, immediately. Okay. On the effective date. There we go. I'm okay with that, and I don't see any different language from NMOGA or the other parties.
This, Commissioner, are you moving to adopt?
Mr. Chair, I move to adopt.
I second.
Any opposition? Without opposition, subsection E is adopted. Am I correct that the next section is to be debated is now the newly enumerated 1915-25-13? I'm missing one. Oh, I'm sorry, 1915-25-10. I don't have any objection.
We have a numerical update, and if
From
there be any
11-12.
objection, I would move to approve 1915-25-10 notice of plugging.
I second.
Any opposition? Without opposition, so adopted. Now 1915-25-13.
When you're ready for me to describe Oxy's
Go for it.
proposal, let me know. All right. It is in C2. You presumably can see what they propose to delete. They propose to delete these words. And the operator shall provide at least 30 days notice of the application for extension in a newspaper of general circulation. In the next sentence, propose to delete the words any interested before the word person, and then except that in any such adjudicatory proceeding, any interested person may intervene under 1915 411A. So their reasoning for these proposals is that the any mandatory adjudicatory hearing for requests to extend already approved TA status are unnecessary and inefficient. The division's docket is at capacity, which would create compliance issues for wells awaiting hearings and decisions. Continuing to evaluate extension requests via administrative applications allows the division to efficiently and effectively